Hi everyone. Let's talk about how I prepare clients for any trial in family law. First of all, trials in family law are conducted by a judge. There are no jury. So the only person who is going to decide your case is going to be the judge. And I always suggest to go and watch your judge in different hearings. All hearings are public, most of them, unless it involves confidential child-related hearings, but you can find out online by going to the Superior Court of your county and see court's calendar and observe it. Usually Zoom observance is not allowed unless you're part of the case, so you gotta go in person. Then first we develop a strategy. When a client hires me, we know exactly where this case is gonna go, and assuming this part of the case didn't get settled, for example, the other side wants sole custody because they claim domestic violence restraining order, or they want spousal support because they haven't worked for 20 years and don't want to work and seeking a long-term spousal support, and there is no way to meet anywhere in the middle or not in the middle, not possible to settle, then we strategize who is going to be our witness, who is going to be, or what is going to be our evidence, and we make a list. Witnesses that are experts would have to be disclosed way more earlier than other witnesses. So there is a deadline for witness disclosures and exhibit disclosures, and that is part of the local rules. However, expert witness, so in domestic violence restraining order case, it could be an expert who specializes in domestic violence, or in custody case, it could be a custody evaluator or vocational evaluator in spousal support cases. Those witnesses have to be disclosed 75 days before, but check, this is California. In different states, different rules, and also you have to look into your local rules. When the witness disclosure is, when the expert witness disclosure could be extended for whatever reason. It could be when is trial brief is due. So based if and when the case goes to trial, outline all the deadlines. Motion in limine. What is motion in limine? For example, in domestic violence restraining order case, you're asking the other side to provide evidence that they're going to introduce in trial, such as video that they have recorded with your consent, without your consent, let's say without your consent. And you look at these videos and you figure out, actually, there is no exception that penal code provides. Therefore, these videos cannot be introduced. And there are hundreds of them. For judicial sufficiency, you file a motion in limine based on the local rules and look at the deadline to say that all these videos needs to be excluded, or the court needs to decide which video can be introduced into evidence out of these 100 videos, and you provide transcription of each video because they were without consent, or there is no exception, or it could be any evidence. I had a case where the judge said in motion in limine, any immigration law related evidence cannot be introduced. So in a domestic violence restraining order case, just so that the other person doesn't get in trouble with INS. Or it could be tax related, or it could be evidence that is late that they're going to introduce cannot be introduced. So the judge will decide as right before the trial begins whether, or even a witness. I had a case where I deposed a lot of witnesses and I figured out that they don't say anything that the other side cannot testify about. Basically, their information is based on hearsay. They heard the other side told them this, and therefore they're going to testify about it. So I was able to exclude these witnesses. What does it do? It saves a lot of time. A trial, you don't want a trial for 12 days. You don't want all the neighborhood to come and testify about one issue that can be testified by the person who is testifying on a penalty of perjury related to this case, the other party. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. So, and then there is the opening statement. So assuming another thing about witnesses, if you have police officers And third-party witnesses, you gotta serve them a subpoena. If you don't know if they're gonna show up voluntarily, most likely they won't, especially police officers. Then you have to issue a subpoena and you have to pay whatever the county requires, $300, serve where you need to serve in your county to the police department that accepts subpoenas so that the police officer has to show up. So you gotta plan all your witnesses, all your records, exhibit list. Exhibit list could be bank statements, emails, text messages, videos, anything that proves your case or disproves their case. And then we also have impeachment exhibits, impeachment witnesses. Those are the exhibits or witnesses that we don't disclose on the witness list. Why? Because they're surprise witnesses. So, for example, if the other side says, I never hit you, and especially not on that day, but on that day, this person not only hit you, they were arrested. Then, of course, your impeachment witness is going to be a police officer who then took the statement from the other side. Although the statement is hearsay, we'll talk about hearsay in all objections. It's admission by the party opponent, so the police officer can testify to impeach the other person's testimony. And so can any witness. So if someone says, I never sent this message, or I never said that, and there is a witness who heard the other party say that, they can come as an impeachment witness. Same goes for impeachment exhibits. Impeachment exhibits are disproving the other person's credibility. I do have a video about impeachment, so I'm not going to go into that in detail. But basically, assuming the framework of exhibits, witnesses, expert witnesses, impeachment exhibits, everything is set up. So what will happen in trial? On the day of trial, the court might ask if either party has an opening statement. If you filed your trial brief, which is part of the process, then your opening statement should be a summary of your trial brief. If you didn't file a trial brief, which I don't suggest filing trial brief. Trial brief doesn't have any attachments, so your exhibit list will have all attachments. So the trial brief refers to the attachments. And then you can say, if the judge gave you 3 hours for your case, then you could say to the judge, I refer to my trial brief and I would rather get into the case right away so that I have my time. And before that, the judge will decide about motions in limine. So sometimes the judge says, okay, we have this case. Each party gets 1 day or 3 hours or 3 days, whatever the time frame is. So you gotta use your time wisely. And when the judge says that, it includes when you speak to the witness, which means not only you ask questions on direct, what's your name, whatever the direct is, but also when the other side finished with their witnesses or one witness direct, you cross-examine that witness. That goes against your time. So you got to be careful. Whenever you speak to a witness, that time goes against your assigned time. I suggest also to do role plays with an attorney and a client, because sometimes, I would say 80% of the time, if a witness is not prepared, they do not know how to answer a question. Because what happens if the other side is asking them a question that they don't like, they start to answer a different question. And the judge gets really annoyed because they just say, just answer the question. Just answer the question. Did you or did you not hit your husband or your wife on that day? Well, don't tell me the story why you were upset that day. That's not the question. On the day of trial, the court will swear the parties in. Usually that's done by a court clerk who says, stand up, raise your right hand, tell that you will testify the truth, nothing but the truth. When I do, and the penalty of perjury, please sit down. And then whoever has the case in chief, meaning whoever is asking for something. So it could be wife or husband asking for domestic violence. It could be wife or husband asking for spousal support. Whatever that is, that person goes first. You can agree with the other side to say, okay, well, if it's not clean cut, if you're the petitioner, you go first. If it's a trial on all issues and nobody goes first, because then you can agree the petitioner goes first. And then once it's called case in chief, meaning their main case, they have the witness list, they have impeachment, so they go first. And then the other side, whoever that is, could be petitioner, respondent, they go next. And sometimes the witnesses are the same. So if both of you have parties as witnesses, then the party who goes first asks direct questions. And I like to go first because that's the first impression. When you ask direct questions, you give the opportunity your client to explain the story without hostility, without interruption, just tell your story in a way that aligns with the code section. So you don't tell the story about something that is unrelated. So if it's domestic violence, then you tell the story how it led to what happened. If it's spousal support, then you explain why spousal support is appropriate or not appropriate. And you go through the factors, 4320 factors. If it's child support, then why it's in the best interest for the child to you be the sole custodial parent or something like that. So basically, you have to keep an outline of the questions. So then the attorney is asking direct examination questions. Then the other side is asking cross-examination questions. And those questions can be leading. Well, isn't it true that you said this, but in reality is that? But isn't it true that you actually sent this email? And no, I didn't. Here's impeachment email to show that you did. So the other side could be confrontational, which is part of the cross-examination. And then if you feel the question was yes or no, but you wanted to explain, so the other side says, well, isn't it true that you hit this person? Well, I did, but it wasn't that wasn't the question. Strike it. Strike the answer. You did hit this person, right? Yes, I did. Then the recross. So after the cross-examination is done, then the recross, I would be giving the opportunity to the witness to explain, why did you hit the person? Well, it wasn't a self-defense, but they didn't give you an opportunity to explain, which is usually already in the direct. So I anticipate what questions will come and cross. So we embed this to the story. But if it's not possible because something new came up, something unexpected, completely unrelated, then the recross allows the opportunity to recover from the cross. So when that is done, then whoever has the case in chief has the opportunity to call impeachment witness. Who can be impeachment witness? Anyone. It can be even your own client, because sometimes what happens, I put my own client on the stand, the other side puts their client on the stand, I cross, and they bring up new evidence that was completely unexpected because it's completely new. Then I put my client on the stand to rebut or impeach the test. So rebut the witness credibility or impeach the witness credibility or rebut the evidence. Bring my own evidence from the client to contradict the statement that was given. Etiquette, how to dress. Dress the way you dress when you potentially go to job interview. So if your job interview is at a startup company, they're casual attire, then of course you're not going to dress as if you're going to a funeral or something. Basically, it has to be you, but respectful kind of you. So you don't come with sweatpants and obvious, right? So it's casually formal. How do you address the judge? You address the judge, your owner. What you don't do, you don't argue with the other lawyer. For example, if they ask you a question and you don't understand the question, you don't say, well, actually, you're wrong asking me this question because this and this and this happened. No, you just say, I don't understand the question, or repeat your question, or are you asking for a specific time period, or basically admit that you don't understand or you need clarification. Don't argue with the other side. So you're not allowed to ask counter questions. Let's talk about objections. The most common objection is hearsay. So when a witness testifies, they cannot say someone told me unless that someone is the other side, because it's called admission by the party opponent. So whatever someone told me, not good. The witness only testifies about personal knowledge and personal observation. That's all the witness does. The second common objection would be leading. If someone who's on direct asking questions or isn't it true, then it's leading. The witness has to have some what happened on that date instead of isn't it true that you hit this person on this day? That's leading. So that's a position on cross is allowed to ask leading questions. Compound. Compound is when one question includes 5 facts. Well, isn't it true that when you hit this person, you ate X and bacon for breakfast and you were driving a car? So if you say yes, then you say yes to 3 things. So you got to be careful not to say yes, and you got to be careful to object on time, to not have the witness slip and say yes to everything. So before you answer a question, give 3 seconds to think for your lawyer to object and for you to answer, to see if this question is compound, leading, speculative. If I ask you, how big is your table in your office? You would estimate. But if I ask you, how big is the table in my office, and you don't see the full table, then you would be speculating. So a witness is not allowed to speculate. What were you thinking? Not you, but let's say the witness says, what was the other person thinking? That would be speculation. They don't know. They must have been thinking this because they said that. No, that doesn't work. So speculation is not okay. And then behavior. It's easy to get upset or irritated or dismissive or argue with opposing counsel. It's important to focus on just the question and answering the question. Behavior should be calm, non-confrontational, no matter who is asking the question. So I think that's all I got. I don't want this video to be too long. So if you have any questions, comment down in the section below, and I will see you in my next video. Bye!